Welcome to the 2024 Court of Appeals Roundup. My name is Alexander Gilbert. I'm an attorney here in New York, and I have practice experience in the areas of family law, guardianship, negligence, medical malpractice, and criminal law. But the reason why I'm here is because starting in January of 2023, I started a YouTube channel where I cover every single case from the New York Court of Appeals that's substantial. I make a video discussing the background knowledge that's helpful to understand the case, the procedural history, the facts of the case, and ultimately the holding. And last year, for the first time, I presented a year in review of the 2023 cases, and they asked me if I would be willing to do that again this year, which I am happy to do. So I've got about 90 cases to cover. I'm going to try to do it in the next hour and a half or so. So I'm going to get started right now. I will say, if there's any case you want to know more about, because I'm obviously not going to have the time to cover them in depth here, but every single case you see, with very few exceptions, has a complete 5-minute long or more video discussing that case in depth. And I would encourage you to go to the links of my channel, and you can find any of those cases in depth. Let's start getting into it now. I'm now going to talk about the tort law cases this year. The next case I want to talk about is the case of Timperio versus Bronx-Lebanon Hospital. This is a workplace shooting incident inside of Bronx-Lebanon Hospital, where a former employee walks into the hospital with a gun and shoots up the place, including shooting Mr. Timperio, who's an employee. So Mr. Timperio is injured in the course of his employment at Bronx-Lebanon Hospital and applies for workers' compensation benefits. What you have to know, the little bit of background here, is that there's a presumption that applies. Workers' Compensation Law 21(1) says that when an injury arises in the course of workers' employment, it is presumed to arise out of the workers' employment and therefore is compensable absent substantial evidence to the contrary. So there's a presumption that applies. But here the Workers' Compensation Board wanted to say, no, this wasn't from the employment. This was from a gunman who had some kind of motivation that was beyond the scope of employment. And so the appellate division here agreed with the Workers' Compensation Board. It goes to the Court of Appeals. And the issue here is, does lack of evidence as to the motivation for the assault rebut the presumption that it's covered by workers' compensation benefits? And the Court of Appeals says, no, it does not. The presumption applies in cases involving assaults that occur at work. A lack of evidence as to the motivation for the assault does not rebut that presumption. So because the presumption applied and was unrebutted, nobody actually showed the motivation for the assault, neither the plaintiff nor the Workers' Compensation Board. Therefore, the presumption is triggered and is not rebutted. Therefore, it's compensable. The appellate division applied the wrong standard here, saying that it was the plaintiff's burden to show what the motivation here was, and that's not the standard. It's a presumption unless rebutted. The next case I want to talk about is the case of Colt versus New Jersey Transit Corporation. And this is a case where a New Jersey Transit bus was driving to and from New Jersey to the Port Authority, and on 40th Street in Manhattan, it struck and injured a plaintiff who then sued New Jersey Transit. New Jersey Transit replied with a bunch of different defenses, including a bunch of boilerplate defenses, including lack of jurisdiction, but never specifically said sovereign immunity. Okay. And they engaged in discovery. They deposed multiple people, including the plaintiff, including employees of New Jersey Transit and witnesses. And eventually, 3 years into the case, there's a motion to dismiss for on the grounds of sovereign immunity, that New Jersey Transit is the alter ego of New Jersey. And since the plaintiff can't sue New Jersey in New York State court, it would defeat sovereign immunity. Ultimately, that action, that claim, was denied by the court. It was that was affirmed by the appellate division, and it goes to the Court of Appeals. This was briefly addressed last year, or in 2022, but they said it was not yet final, so they couldn't finally address it, and they address it here. And ultimately, they say, based upon, they analyze it in the context of a Supreme Court case called Franchise Tax Board of California versus Hyatt, which talked about sovereign immunity from the United States Supreme Court perspective. And ultimately, they say this is what the Court of Appeals says. We glean from the court's analysis, the Supreme Court's analysis, that the relevant inquiry here is whether subjecting a state-created entity to suit in New York would offend that state's dignity as a sovereign. And we hold, in answer to that question, that courts must analyze how the state defines the entity and its functions, its power to direct the entity's conduct, and the effect on the state of a judgment against the entity. And considering all those factors in this case, the Court of Appeals says it does not offend New Jersey's sovereign dignity by allowing a New York resident who's injured by a New Jersey transit bus to sue the New Jersey Transit Authority in New York it does not defeat sovereign immunity. Particularly, they're not happy with how long it took. They didn't just assert this in the preliminary answer and then litigate that initially. They waited 3 years before they established finally this whole sovereign immunity claim in the motion. And for that long delay, that's part of why it offended the Court of Appeals here. And they're saying it does not defeat sovereign immunity. A New York plaintiff can sue New Jersey Transit without it offending sovereign immunity. The next case I want to talk about is the case of Sabine versus State of New York. This is a case that's kind of unsatisfying. The question before the Court of Appeals is, does pre-judgment interest in a personal injury case arising from a motor vehicle accident, should that start accruing from the date liability is established, or the date at which the finding is made that plaintiff sustained a serious injury? Under Insurance Law 5102. Ultimately, the Court of Appeals says the majority says we're not going to address that because it's not been properly preserved below. But Judge Rivera does issue a dissent where she would accrue it at the point at which liability is assessed. And that's the case of Sabine versus New York. Next, we'll talk about the retirement law cases. Next case I want to talk about is the case of Cologne versus Teachers Retirement System. This is a case in which a law passed during the COVID-19 pandemic that retroactively classified COVID-19 deaths as accidental disability benefits as opposed to ordinary death benefits. Is that a violation of the New York State Constitution's pension impairment clause, or is it valid? And ultimately, the reason why it matters is because if it's an accidental death benefit, the beneficiary of the money is different than if it's an ordinary death benefit where there's a designated beneficiary. And ultimately, the person who was not going to receive the money complained and said, "You've impaired my right to the pension that I was going to get." And ultimately, the Court of Appeals, in resolving that issue, said, first of all, there's no vested right in the person who would be the designated beneficiary under the ordinary death benefit. And secondly, accidental death benefits are always better. They're always either equal to or better than ordinary death benefits. So there's no diminishment. There's no impairment of pension benefits. In fact, they're improved. They're elevated. It's better benefits. So it's not a violation of the pension impairment clause. The next case I want to talk about is the case of Rawlins versus Teachers Retirement System of the City of New York. This is a case where a principal of a school in the city was the target of a months-long campaign of sort of harassment and stalking, allegedly by a coworker, by a person, I think it was either the janitor staff or security staff. And ultimately, she claims that she got PTSD and had to apply for accidental disability benefits. And it was denied by the board. And the question before the Court of Appeals was, does the fact that it was harassment by a coworker mean that it cannot be accidental disability benefits? The board actually denied her application for accidental disability benefits. And the holding by the Court of Appeals is they uphold the board's determination. They say the board had valid grounds to say that this was not accidental because they say it's not proven that this was sudden. This was over many months. It's not proven that this happened on school grounds. But they do make a point of disagreeing with the board and the appellate division by saying there's no bright line rule that says you cannot have accidental disability benefits if the injury results from a coworker. They disagree with that proposition. They say the fact that a coworker caused the injury does not preclude a finding of accidental disability benefits. But in this particular case, the board's determination that it's not accidental is upheld. The next case I want to talk about is the case of Compagnone versus DiNapoli, in which a police officer is patrolling around a house that's under construction, and he falls into a hole in the ground because it's a construction site. There's a hole in the ground, and the question is, when he's injured by that fall and applies for accidental disability benefits, is he entitled to it? Is that truly an accident? And the Court of Appeals here, their holding is that it's not an accident. Why? Because it's part of the normal risks inherent in the job of being a police officer. They say you're not entitled to accidental disability benefits if it's the normal risk that results in your injury. And here, the risk of patrolling around in a dark area around a house, which is what he was doing, responding to a call of a possible party at a house, that is the risk inherent being a police officer. So he can't get accidental disability benefits when he does that and then gets injured as a result. The next case I want to talk about is the case of Bodenmiller versus DiNapoli. This is a case where a police officer is in a police precinct and he's leaning back in a chair and he knows there's like a rut, a defect in the floor, and he leans back too far, almost falls backward and grabs his desk, resulting in an injury to his neck and his back. And he applies for accidental disability benefits. And the question here is, does the fact that he knows that there's a rut in the ground where he's doing this balancing with the chair, does that mean he's not entitled to accidental disability benefits? And the Court of Appeals here, the holding is, that is correct. He's not, because he's aware of the rut. They say that part of the elements of being entitled to accidental disability benefits, it has to be surprising, has to be unexpected. It can't be a part of the job. It can't be a normal risk of the job, but it also can't be something that the person is aware of. And here, the fact that the officer was aware of the defect means that he is not entitled to it because it's not a surprise. Next, I'm going to talk about the property law cases. The next case I want to talk about is the case of Elizabeth Street Garden versus City of New York. This is about an urban green space in Lower Manhattan where there was an application to change the use of that space. This went before the Department of Housing Preservation and Development, which is called HPD, and a State Environmental Quality Review Act assessment was done, and they have to perform what's called a hard look to see if there's an environmental impact that's adverse to the city. They perform that, and ultimately they decide that it's okay to make the changes. And the question was, did their lack of any inclusion specifically of whether this would affect climate change, does that invalidate the hard look and ultimate determination made by HPD? The majority holding in this case is that no, it does not. There's no abuse of discretion here. That's the ultimate question here. The judicial review is, was it arbitrary and capricious or abuse of discretion or affected by an error of law? And none of those things apply. So the majority would say it's fine. There was a strongly worded dissent, I believe, by Judge Rivera, who indicated that the lack of any acknowledgement of climate change is itself a defect that would be grounds to overturn it. But the majority is no, this is fine. Next up is the case of Liggett versus Lew Realty. And the issue in this case is whether a landlord of rent-controlled or rent-stabilized apartments can enter into a stipulation or an agreement with a tenant to basically change the nature of the apartment away from being rent-stabilized to being a fair market rent unit. And the holding from the Court of Appeals is no, that is void as against public policy. They hold specifically accordingly. The stipulation at issue here, which required the tenant to waive his right to a fair market rent appeal, is void and did not provide a path to deregulation of the subject apartment. Any agreement waiving a benefit of the rent stabilization laws is void as against public policy. Next up is the case of matter of 160 East 84th Street versus New York State Division of Housing and Community Renewal. And the issue in this case is the rent stabilization law. And basically, for a time, there was a way to luxury deregulate rent stabilized units if the owners for 2 years or more had incomes that exceeded the threshold for rent stabilized eligibility. And so there was an ability during that period of time to take certain units off of the rent stabilized system and make them fair market rate units. But there became sort of a crisis moment where they realized, the legislature realized they were deregulating too many. This was going to take away all the affordable housing in the city, or much of the affordable housing in the city. So they quickly undid that and passed a law basically saying, as of June 14th of 2019, unless your lease is expiring that day or earlier, it doesn't matter that we issued a previous order saying that it would be deregulated. Anything that hasn't been deregulated by that day or no lease expiring by that day, it's going to stay rent stabilized, even though we previously said it would be deregulated. And so ultimately, one of the landlords here that was upset because they were going to get a lot more money from the fair market rent, basically made this application, had this lawsuit saying this was unfair and violated their rights. And ultimately, the holding from the Court of Appeals is it does not violate their rights. There's no landlord that has a right to get their unit off of rent stabilized system. Maybe they want to, but it's not their right. And the law here is valid. There was one case in the Medicaid area this year, that case being Aaron Manor Rehab versus Zucker. And the issue in that case is whether the Medicaid reimbursement rates that the legislature changed immediately without giving any advance notice to all the providers, is that legal given that Public Health Law 2808 requires that there be 60 days advance notice given to providers before they're required to accept these new rates. And the holding from the Court of Appeals is it's okay because the legislature specifically gave a date. They are the lawmakers, and they're allowed to overcome their own laws. So it's not a constitutional issue. It's a statutory inconsistency. But because the legislature said it takes place immediately, it's effective immediately, they're allowed to do that. It does not matter if it violates Public Health Law 2808 because they've overruled that by statute. There was only one matrimonial law case this year, and that was the case of Szypula versus Szypula. And the issue in this case was whether pre-marriage but unbought pension credits were marital property or separate property. In this case, the husband served in the Navy for 9 years, but didn't buy that as pension credit until after he was married and used marital funds to buy that pension credit for the years he served in the Navy. And the question is that pension service, is the pension benefits a marital or a separate asset? And the holding from the Court of Appeals is that it's a marital asset because there's a broad presumption in favor of calling things marital assets and against calling things separate assets. And when you commingle funds, when you use your funds as a married couple to buy back property, including pension benefits like this, it's considered marital assets at that point. Next, I'll discuss the education law cases this year. In the case of O'Reilly versus Board of Education, the issue is whether teachers who were fired during the COVID-19 pandemic for failing to provide proof that they were vaccinated, are they allowed to challenge that firing, that discharge, that termination on the basis that they were not given their entitled hearings under Education Law 3020 sub A? And the answer from the Court of Appeals, the holding is no, because it's a condition of employment, not a disciplinary proceeding. So if teachers are going to be disciplined, they're entitled to a 3020 hearing. But if it's a condition of employment, they're not entitled to that hearing. And the vaccination requirement was a condition of employment. Next is the case of Matter of United Jewish Community of Blooming Grove versus Washingtonville Central School District. And the issue in this case is whether Education Law 3635 sub 1, which requires school districts to provide sufficient transportation to all their students attending school in the district, whether it's private school or public school, does that law require the district to pay for, to provide transportation to the private schools, even on days when public schools are closed? And the holding from the Court of Appeals is no, it does not. They say that's the kind of thing that would be a lot of money and really should go to the legislature. They're not going to interpret Education Law 3635 sub 1 to require school districts to provide these extra 20 days, even when the schools are closed, to private schools for transportation. Next is the constitutional law case. In the case of Roman Catholic Diocese versus Vullo, the subject matter in this case is the health insurance laws that require that coverage include abortion coverage, and that includes that's applicable to all employers, including the Catholic Church, unless a specific set of exemptions apply. And there's a variety of elements to those exemptions. And prior to this case, essentially, and including this case, the Roman Catholic Church and the nuns were required to provide health insurance coverage that included abortion coverage. They were not exempt from it because of the elements were not all met. And they challenged that, and they said this is a violation of our religious liberty. And they said they wanted the exemption. It was not fair. And ultimately, the Court of Appeals holding in this case is that because there was no discretion being left to government officials to pick winners or losers, this was not a case-by-case analysis. It was simply a sort of a yes or no analysis. Do all these elements apply to you? And you self-certify that they do or don't. It's not a violation of religious liberty. It's a law of general applicability, and the law stands. Next, I'm going to talk about the civil rights law cases. The next case I want to talk about is Clifton Park Apartments versus New York State Division of Human Rights. This is an important case for all of us lawyers to know. The issue in this case is whether a lawyer letter, a demand letter to withdraw or cease and desist on threat of litigation, say, you have to withdraw what you're doing or else we'll sue you, whether that can constitute a retaliation violation sufficient to invoke the human rights law. And basically the Court of Appeals says yes, that a letter's threat of litigation, it's unlawful to retaliate against a person for opposing discriminatory practices. So if someone claims there's discriminatory practices and a lawyer says, cut it out or we'll sue you for defamation, that could be sufficient retaliatory threat that would justify a claim under the human rights law. So even a lawyer letter threatening litigation is sufficient under the human rights law. It does not get dismissed out of hand. It goes through discovery. The next case is Ibhawa versus New York State Division of Human Rights. This is an interesting case where the plaintiff is a priest who sued the church for a couple of different claims, including hostile work environment as well as wrongful termination. They were doing allegedly racist things to this Nigerian-born priest. And basically, the Supreme Court below, the trial court, dismissed the case on the grounds of First Amendment, saying there's no jurisdiction on the part of the court because because of the ministerial exception, because this is religious institutions fighting it out with their religious clergy. But the Court of Appeals reversed it and said, wait a second, the ministerial exception is an affirmative defense. It's not a jurisdictional defect. It's an affirmative defense. So as to the hostile work environment claim, that should at least survive and let you go through discovery, and then we'll see where we are and if it's appropriate for the affirmative defense to apply. But it's not a jurisdictional defect, and that the Supreme Court's dismissal is reversed. The next case I want to talk about is the case of Syeed versus Bloomberg. And the issue in this case is whether a non-New York resident, a person who does not live or work in New York, but aspires to work in New York, has applied to a job in New York, can that person, when they feel like they have been discriminated against in violation of the human rights law, can they file a human rights law claim, even though they don't live in New York and they don't work in New York yet? And the holding from the Court of Appeals is yes, they can. That law is designed to be read broadly, and it's designed to protect not just New Yorkers, but people who aspire to live and work in New York. The next case I want to talk about is the case of Russell versus New York University, NYU. And this involves a case where a teacher from NYU sued NYU in federal court first and ultimately lost, was dismissed for the plaintiff's failure to prove essential elements of the discriminatory conduct claim. Plaintiff then filed the same action essentially in New York State Court, and the defense NYU moved to dismiss based upon collateral estoppel grounds, claiming that these issues essential to the claim were already litigated and resolved in the defendant's favor. This goes to the Court of Appeals, and the issue is, does the federal court dismissal on specific issues based upon plaintiff's failure to establish specific issues that are also relevant in the state court claim mean that it's subject to dismissal in the state court? And ultimately, the Court of Appeals holds that it is. They remind us that collateral estoppel bars relitigation of issues of fact or a law that are actually litigated and resolved in a valid court determination essential to a prior judgment, even if it's filed in a different claim in a different court. And in this case, they say that where a federal court, such as here, has made an explicit finding that the plaintiff produced no evidence on the relevant specific factual issues in litigation, it is subject to collateral estoppel dismissal in state court also. The next case I want to talk about is the case of McCabe versus 511 West 232nd Owners Corp. This is a case where the issue is whether non-married partners, long-term non-married partners that are not treated the same as married partners, are they allowed to sue under the human rights law as a violation of their equality under the concept of marital status discrimination. This centers around a co-op board where there was an apartment that was lived in by two long-term partners that were not married, and they tried to put the shares from the one partner who owned the building, who owned the unit, into the other person's name, but the co-op board wouldn't let them do that because they weren't married, and ultimately the owner of the unit willed his shares to the long-term partner. And when he died, the co-op board basically tried to evict the remaining partner, because they were not married. And she then sued them and said, wait a second, I'm the long-term partner. You're discriminating against me on the basis of my marital status. That violates the human rights law. And the Court of Appeals holding in this case is it does not. The majority holding here was that the human rights law does not necessarily. This was not a violation of the human rights law. They weren't discriminating against her marital status. They were discriminating against her being not married to this particular person, Mr. Burroughs. It wasn't that she wasn't married in general. It was that she wasn't married to the owner of the co-op unit. And that's the defect that did not allow her to continue living in the building, not the fact that she was unmarried generally. But there were two strongly worded dissents by Judge Wilson and Judge Rivera. But the majority holding is that this was not a violation of the human rights law under these particular circumstances. There were two civil procedural cases. Next up is the case of Favorite Limited versus Chico. And the issue in this case is whether after appellate court dismisses a complaint, does the trial court have the authority to grant an amendment to that dismissed complaint? And the holding from the Court of Appeals is yes. Just because a complaint's been dismissed by an appellate court, that does not deprive the trial court, the lower court, of the ability to amend a complaint that's already been dismissed. In fact, they say under CPLR 3025 that a party may amend his or her pleadings at any time by leave of the court, and that such leave shall be freely given absent surprise or prejudice. And that's the case of Favorite Limited versus Chico. Next is the case of Knight versus New York Presbyterian Hospital. The issue in this case is enforcement of a contractual venue provision. And there's a dispute as to whether the person who's alleged to have signed the document that contains that venue provision is the actual signer or if it's some forgery, if it's a forged document. And on that issue, the question that presented itself in this appeal was who has the burden of persuasion, who has to rebut that presumption, rebut the burden. And in this particular case, they have a very succinct holding from the Court of Appeals. They say, in sum, when the authenticity of a document is put in issue on a motion to change venue pursuant to CPLR Article 5, the party relying on the document, putting the document forward, has the initial burden of establishing its authenticity. Here, DeWitt met that burden. Plaintiff, in turn, then failed to establish a tribal issue of fact as to whether the signatures were forged. So upon satisfying that burden of production and persuasion, it then flips, and the other side failed to rebut that burden, failed to rebut that finding and that showing. And that's the case of Knight versus New York Presbyterian Hospital. Next is the case of Ruasich versus Structured Tone. And this actually has a couple of issues. One is a labor law issue on Labor Law 241 about slippery surfaces. And the Court of Appeals in that area says that pebbles, little tiny broken pebbles in the insulation of a large glass sliding door is not considered integral to the work, and therefore a labor law claim would be viable. But more importantly, with respect to civil procedure, they discussed the nuances and the mechanics of how the 30-day clock works for appellate purposes in terms of having to apply the 30-day period for taking an appeal to the Court of Appeals. They say this was late. This was 31 days. So they say the appeal is untimely. So if you have an appeal issue, consult this case with respect to electronic filing deadlines. Next, we'll talk about the business law cases. Next up is the case of Taxi Tours versus Go New York. This is an anti-competitive Donnelly claim kind of a case, and the issue is sufficiency of pleadings. So in this particular case, Go New York was claiming that it was being kept out of the marketplace by anti-competitive practices and conspiracies amongst different other competitors and exclusive attractions in New York. And the question was, are there pleadings sufficient to make out the claims that are being made? And ultimately, while the Supreme Court and the Appellate Division had said it was insufficient, the Court of Appeals reversed, said we have a liberal pleading standard in New York, and the allegations made in this particular case, which are pretty specific. So if you have this kind of a case, you want to read the actual case, were sufficient. So they reversed it and they say you should at least go through discovery. On the case of Eccles versus Shamrock Capital, this is a case about FanDuel, which is a company that has its origins in Scotland, but it does business in New York. And it's a choice of law kind of a case. And the question is, when the claim is a shareholder against the company kind of fight, and it's about what happened with the internal organization of the company in Scotland, which law applies, which substantive law applies, New York law or Scots law? And the Court of Appeals in this case says that with respect, the general rule is with respect to procedure, New York law will apply. With respect to substance, the original jurisdiction will apply. And they make a specific rule. They make an important change here. They say, consistent with our precedent, we clarify here that the substantive law of a company's place of incorporation presumptively applies to causes of action arising from its internal affairs. And to overcome that presumption, the party must demonstrate that the interest of the place of incorporation is minimal, basically virtually no contact other than the place of incorporation, and that New York has a dominant interest in applying its own substantive law. And in this case, those don't apply, so Scots law applies. The next case I want to talk about is the case of Lelchuk versus Societe Generale de Banque Liban. This is a case where one bank buys another bank's assets and liabilities and then gets sued in New York subsequently. And the question is, does New York have jurisdiction over this bank because it bought all the assets and liabilities from a New York bank before? And ultimately, the Court of Appeals says yes, that under New York's long-arm statute, CPLR 302, when a company buys the assets and liabilities, all the assets and liabilities of a seller, but does not merge with the entity, it inherits the acquired entity's status for personal jurisdiction in New York. The next case I want to talk about is Kasowitz versus JP Morgan. It's a little bit of a complicated case. Essentially, the issue in this case is whether a lien holder, non-party to an action that results in a fee award to a debtor can, in a later situation, in a later case, challenge the legal basis of that judgment in a separate proceeding to recover those fees. And while ultimately the Court of Appeals says they can, they can challenge it because because joinder is different than intervention. Joinder is mandatory, but intervention is permissive. So even though a lien holder, non-party, could have tried to intervene earlier, it was not required to. So just because it could have earlier does not mean it's prohibited from doing so later to challenge the judgment itself. This year, there was one case in the attorney disciplinary area, that case being Urias versus Botafuco. And the issue in this case is whether a client can sue the lawyer under Judiciary Law 487 on the basis that the lawyer allegedly committed deceit or fraud or lied to the client. Can you do that in a plenary action and a wholly independent action, or do they have to go back to the original court that resulted in the judgment and bring that case there? And going to the Court of Appeals, the holding by the Court of Appeals is that Judiciary Law 487 authorizes a plenary action, a separate action in a different court than the court that actually handled the case, even if the outcome of that plenary action would dispute or undermine or somehow seemingly validate the underlying judgment or cause of action that the lawyer handled. So you don't have to go back to the same court that handled the case originally. You can file an independent cause of action against the lawyer in a separate court in a plenary action. That's the holding from the Court of Appeals. This year, there was one insurance law case, that case being Consolidated Restaurant versus Westport. And the issue in this case is whether a restaurant that has an insurance policy that protects against direct physical loss or damage can be redeemed. A claim can be made based upon this SARS-CoV-19 pandemic, when people didn't want to go to restaurants, when there was widespread fear of being in public places. The restaurant in this particular case filed a claim saying this was a condition protected by the insurance policy, and the insurance company denied it. Went to the Court of Appeals ultimately, and they agreed with the insurance company. They held in this case that a direct physical loss or damage requires a material alteration or a complete and persistent dispossession of the insured property, which is not alleged by petitioner in this case. The mere allegation that there's a pandemic and people aren't going to the restaurant because of the pandemic and that there's droplets in the air is not sufficient to allege sufficiently a direct physical loss or damage. I'm going to talk about the election law cases this year. That case being Stefanik versus Hochul, and the issue in that case was the constitutionality of the new law passed by Albany, the universal no excuse mail-in voting law that allows you to mail in your vote even if you have no hardship or you're not away on business or in the military. And the Court of Appeals said that basically anything, there's a strong presumption of constitutionality by anything passed by the legislature. And because there's nothing in the plain text of the Constitution that prohibits it, the legislature is allowed to pass this kind of a law and enjoys that presumption of constitutionality. The law is constitutional. The next case I want to talk about is the case of Amador versus New York. And the issue in this case is whether election law 9-2092G violates New York's constitution, which requires that both primary political parties have equal representation with respect to boards assessing the validity of ballots that are cast. In this particular case, the law 9-2092G says that if there's a disagreement about the validity of a ballot, it's set aside but can presumptively valid, not presumptively invalid. And the question is, does that mean that there's a lack of equal representation? Because one party would say it's invalid, the other party would say it's valid. And the Court of Appeals, in assessing that question, says that the argument fails. Equal representation does not mean that either side has a veto power, which essentially is what petitioner's argument here is. And because the petitioner in this case failed to meet the heavy burden, similar to the other case, of proving that the law is unconstitutional, it enjoys that presumption of validity and constitutionality, and it is valid and constitutional. I'm now going to discuss the labor law cases this year. The next case I want to talk about is the case of Matter of Agramonte versus Local 461. And the issue in this case is whether members of a union can sue the union for injunctive relief, for non-monetary relief, and in such a case, whether they have to allege and plead and prove ultimately that every single member of the union is equally situated and in favor of that lawsuit. There's a previous case called Martin versus Corin, in which the Court of Appeals had previously held that all members of a union have to be alleged in the pleading to be in favor of the lawsuit. And in this case, that was not alleged because only certain members of the union are the seasonal lifeguards who are suing for injunctive relief. And the Court of Appeals here held that because it's non-monetary relief being sought, injunctive relief, not every single member of the union need be alleged and pled to be in favor of or part of that lawsuit for it to be validly pled and proven. The next case I want to talk about is the case of Bazdarek versus Alma Associates. The issue in this case is whether labor law 241's prohibition against a foreign slippery substance is violated by the use of a slippery plastic sheet that results in a disabling injury to a construction worker on an escalator who's painting the escalator. And the holding in this case is that yes, the plaintiffs established summary judgment in this case because they demonstrated prima facie that the plastic covering, the sheet that was covering the escalator, was a slippery surface and not integral to the laborer's paint job assignment. And in response, the defendants failed to raise an issue of fact. So a plastic sheet may be that slippery surface under Labor Law 241. Next, we'll talk about the municipal law cases. The next case I want to talk about is the case of Alcantara versus Nucci. This is a claim against the Department of Corrections for failing to allow sex offenders living in a residential treatment facility in Fishkill the ability to go out into the community and get work opportunities, training opportunities, rehabilitative opportunities. And instead, because there's no such opportunities in Fishkill, basically requiring them to stay inside the gates of Fishkill residential treatment facility. And ultimately, the Court of Appeals, on a claim as to whether or not the Department of Corrections is allowed to do that, says they are not allowed to do that. They say, we hold that DOCS's, which is the Department of Corrections and Community Supervision, their wholesale refusal to secure such opportunities for Fishkill residential treatment facility residents constitutes a violation of the statute. So they do find a potential liability on the part of DOCS for their failure to comply, because one of the elements of the definition of a residential treatment facility is that such opportunities for rehabilitation and education and training and outside opportunities is part of the definition of a residential treatment facility. The next case I want to talk about is the case of Calabrese versus City of Albany. This is a municipal liability case where essentially the city fixed a water main break, and there were many complaints that were made subsequent to that city fix, where there was claims that the street wasn't right, there was defects in the way that the concrete was patched, and all the complaints were routed through the C-Click Fix system, which is like an online reporting mechanism that the city encouraged everyone. Basically said, if you're going to complain about something with the city and the way that the city was running, or the way that the streets are, you must file it through the C-Click Fix system online, typing it in. But they also make you acknowledge when you do that it's not the same as written notice. Okay. And there's a statute that says if you're going to sue the city of Albany, this is the city statute, you must provide written notice. The 2 months after the city patched up that problem with the street, the plaintiff was riding a motorcycle and fell down where that patch was and sued the city, saying it was defective. And they were on notice of these previous complaints that were made about it. And the city in defending it said, no, we have no written notice. There's been nothing in writing. No one put pen to paper here and submitted a complaint. And our Commissioner of Public Works specifically has a policy where he never reviews any of the C-Click Fix complaints. So, and the statute says that it must be written notice, actually viewed by the Commissioner of Public Works. And their Commissioner of Public Works never reviews it. So the question before the Court of Appeals here is, does the C-Click Fix online reporting satisfy the writing requirement? And does the fact that it gets diverted to different people in the organization, but not viewed by the Commissioner of Public Works, satisfy the actual viewing by the Commissioner of Public Works element? Because then you'd have notice. Without that, you would have a defective notice situation. The Court of Appeals here addresses each of those in turn and says, because they're encouraging and making everyone file their complaints via the C-Click Fix system, it does satisfy the writing. Even though it's typed in, that is a writing. That is a writing. And because the Commissioner of Public Works can't just say, I'm not going to view all the complaints, the fact that he has set up a system where his underlings review all the complaints and then make the corrections that they have to make, that the fact that he doesn't actually view it does not provide a defect to the notice here. The plaintiff has satisfied the notice statute, even though it's electronically sent and the Commissioner of Public Works never actually viewed it. That's the case of Calabrese versus City of Albany. The next case I want to talk about is the companion cases of matter of Jamie versus City of New York and Orozco versus City of New York. These are cases that involve claims against the City of New York, and therefore a notice of claim must be filed within 90 days of the date of accrual of the cause of action. There is, of course, an ability to ask for a leave to file late notice of claim, But the general rule is that the city has to have actual notice, or someone in the city has to have actual notice of the claim for the court to grant that application. In this particular case, the court granted the applications to file late notice of claim on the basis that the city actors, the alleged tortfeasors in this case, they knew what they did with respect to malicious prosecution and the claims that were brought in this case. And so the court said, well, I'll allow these late notice of claim. The Court of Appeals reverses on that and says it's not whether anybody that works for the city has alleged actual knowledge of the claim or the facts underlying the claim. They say knowledge of the essential facts as to the time and place by an actor in a position to investigate will suffice. And it's not actually, it's not, in this particular case, they overrule what the court did. They say these particular tortfeasors or alleged tortfeasors, they were not in the position to investigate, and therefore this was improperly granted as leave to file late notice of claim. The next case I want to talk about is the case of Suzanne P. versus Joint Board of Directors. This was a negligence case where there was basically a pond where children kept going there and drowning. And they ultimately, one of these children that drowned sued the Joint Board of Directors of the Erie, Wyoming County Soil Conservation District, which may or may not have owned the pond. And after the trial, at the close of the trial, the judge issued a directed verdict in favor of the defendant on the basis that they don't necessarily own it. And the Court of Appeals on appeal reversed that and said that they should only be used, a court should only be granting such directed verdicts when there's no rational process by which the jury can find in favor of the opposing party. And here there was a rational process by which the jury could deduce or infer that they did own that property. And so they reverse the directed verdict on the part of the court. The next case I want to talk about is the case of Matter of New York City Organization of Public Service Retirees versus Compagnone. The issue in this case is whether Administrative Code 12-126, which requires New York City to pay up to 100% of the coverage for health insurance for its employees, retirees, and their dependents, whether that applies to just one plan or to all the plans offered by the city. The city was saying, well, it only really requires us to pay for one plan, not every single plan. And the other side was saying it requires them to pay for all plans. And ultimately, the Court of Appeals holding here is that it requires them to pay for, and they say, we hold that Section 12-126 requires a city to pay up to the statutory cap for any plan it offers to employees and retirees. So it's not just the one, but it's any plan offered by the city. I'm next going to talk about the tax law cases. The next case I want to talk about is the case of Matter of Brookdale Physicians Dialysis versus Department of Finance. And this is a case that relates to RPTL, the tax law 420-A sub 1, which is an exemption, a tax exemption that's given to not-for-profits that are organized for charitable or hospital purposes. Now, in this particular case, Brookdale Physicians Dialysis is a not-for-profit, but it owned real property that it then leased completely, 100% leased to a for-profit company. But because the owners were this not-for-profit, they chose to try to take that exemption under 420-A sub 1. And the New York State Department of Finance objected to this. And the holding from the Court of Appeals is that this is not allowed. You're not allowed to take that exemption if you're leasing out the property to for-profit companies, because then you're benefiting economically from the lease, and you're getting an unfair benefit and an advantage over competitors because you're not paying any taxes on it. And the holding in this case is specifically real property not used exclusively for the not-for-profit owners exempt purposes is subject to taxation under RPTL 420-A2 if the property is leased to a for-profit entity. The next case I want to talk about is the case of Tax Equity Now New York versus City of New York. It's a complicated case, but basically this tax advocacy organization called Tax Equity Now New York filed a complaint against various defendants, including the City of New York and eight other defendants, alleging violations of the Fair Housing Act and other statutory and constitutional violations. Most of the complaint was dismissed. It goes to the Court of Appeals as to whether the pleadings were sufficient. And the Court of Appeals holds here that because the complaint sufficiently alleged and articulated disparate impact, had charts, had explanations, gave examples, it was sufficiently pled with respect to the city and certain claims. It's a very complicated case. So if you have if you work in this area, you should read this case. The next case I want to talk about is the case of Walt Disney versus Tax Appeals Tribunal. This is actually a companion case with IBM is also another plaintiff in this matter. And ultimately, these multinational corporations were suing the Tax Appeals Tribunal, claiming that they were being double taxed because they had subsidiaries that were being taxed. And they claim that they were being taxed in two different areas by New York when they shouldn't have been. Ultimately, the Court of Appeals holds that the taxation was valid. Their ultimate holding here is the Appellate Division correctly interpreted the statutes as permitting a tax deduction only where a related subsidiary was subject to the add-back requirement, and because any burden on interstate and foreign commerce created by this tax scheme was incidental and did not violate the Dormant Commerce Clause, we affirm. There was one family law case this year. The next case I want to talk about is the case of Jeter versus Poole, and the issues in this family law kind of case. This involves a case where a 13-year-old was alleged to have been struck by the parent with a extension cord. The report was made to the state central registry and a claim was filed. Ultimately, that claim was dismissed in family court, but because it had been made to the state central registry, it persisted, even though the case in family court was closed. And when the plaintiff went to try to remove that state central registry finding, or that state central registry claim about abuse and neglect, the question before the Court of Appeals, first of all, was, is there a right to counsel in such a case? And the answer from the Court of Appeals is there is not. And the other question is, does the fact that it was dismissed in family court, which later on, the law was amended to say that if there's a dismissal in family court, there's a presumption that it should be removed, that it should not be counted against them on the state central registry. Does that subsequent change in the law, is that retroactive to before the law was actually effective? And the Court of Appeals says it's not. It's not retroactive in effect, and there is no right to counsel in these kinds of hearings. Next, we'll talk about the criminal cases. The next case I want to talk about is the case of People versus Aguilar. This is a really interesting case in the criminal context. The issue is, in a criminal case where a justification defense is asserted, self-defense is asserted, let's say an assault, for example, and the jury is given the charges and they ask for a readback on the crime of assault, is it error for the judge to refuse to allow the justification charge to be reread to the jury at that time? The jury didn't ask for the justification charge to be reread, but the defense said, well, if you're going to read assault, I want the justification charge also read back at the same time so that they understand the self-defense, and the judge refused to allow it. The question was, is that error? Was the judge meaningfully responding to the note that the jurors asked? And the answer is the judge did meaningfully respond. The judge has large discretion with how to respond meaningfully to notes. And because the jury didn't ask specifically for the justification charge or ask for things like the justification charge, they just asked for a readback of the crimes, the judge was wholly within his or her right to not additionally charge them on justification. The next case I want to talk about is the case of People versus Baez. This is a case about the admissibility of drug evidence and when there's a problem with the chain of custody. Normally, the Court of Appeals describes in this particular case that the people have an obligation to lay a foundation that an object is what it purports to be, and that its condition is substantially unchanged from the time that was relevant. But if sometimes prosecution or the police officers that the prosecution calls have an unexplained gap in the chain of custody. And the question is that fatal to the admission of the drug evidence? The Court of Appeals says in this case that a gap that is brief and logical explanations for the inconsistencies are provided or reasonably can be inferred from the surrounding circumstances, then such gaps or discrepancies merely raise weight and credibility issues for the jury to resolve. If it's a big gap, if it's days where they lose the drugs and then they find it days later, okay, this might be a gap that cannot be accounted for. But if it's a gap of 10 minutes where one witness sees it and the other witness, they leave it in a locked room, and then the other witness comes into that locked room, that's a brief gap that has an explanation perhaps that can be inferred that will not be fatal to the admissibility of the evidence. In this case, the gap was brief and the conviction is affirmed. The next case I want to talk about is the case of People versus Bone, B-O-H-N, which also talks about the torture murder statute. And the question in this case is whether it's legally sufficient, whether the evidence put before the jury was legally sufficient to establish the element of relishing the murder, sufficient for torture murder. And ultimately, it's very fact specific. And this entire murder was basically caught on audio recording. And he's taunting the victim for a long time. He says he's going to hunt down and kill the victim. Ultimately, this is legally sufficient. So if you have a case on torture murder, this is a good case to read for that purpose. The next case I want to talk about is the case of People versus Boone and Cotto. The issue in this case is when notice must be given to convicted sex offenders who are going to have a SORA hearing. The plain reading of the statute says that notice must be given 30 days before the release from docks upon the completion of a prison sentence. And the question before the Court of Appeals was, is that counted for 30 days, even when the state is considering applying for SOMTA to have them sort of civilly committed as sex offenders that have a dangerous propensity to commit sex offenses in the future. And the holding by the Court of Appeals is that the plain reading of the statute holds it's the 30-day deadline for release, regardless of whether the state is considering filing additional actions with respect to the Sex Offender Management Treatment Act. The next case I want to talk about is the case of People versus Brand. And the issue in this case is whether a defendant who's out on bail and then subsequently gets rearrested for additional Class A or violent felonies, whether the judge at that point can modify the original bail and under what terms and under what procedural safeguards. So for people who work in this area, you should read this case. It's a little complicated for a quick analysis here. But essentially, if a defendant is in that circumstance, gets rearrested on a new case, on a new case, the judge can proceed under different theories of setting higher bail or reassessing bail, but has to be very clear about how they're doing it and under what theory. Because if it's not clear, then they will assume, it says, whereas here, the record does not demonstrate that the court's decision was based on the defendant's increased risk of flight, it will be assumed, for appellate purposes, that the court proceeded pursuant to CPL 530.62A, and the court then must follow all the procedural requirements of CPL 530.62C. And if you don't, it's error. So it's very important that when a person's rearrested, the court has to identify under what theory they're going to change bail, follow the rules of that theory, and that's the case of People versus Brand. The next case I want to talk about is the case of People versus Dunton. And the issue in this case is whether a defendant can be removed from a courtroom during the reading of the verdict and the polling of the verdict without a warning. Normally, the defendant has to be given a warning before they're removed from the courtroom. But the holding from the Court of Appeals here is it is okay, it's allowed, it's not a violation of the Constitution if it's impractical to do so. If the defendant creates a situation or gets violent or yells or becomes dangerous, the defendant can be removed from the courtroom even without a warning. The next case I want to talk about is the case of People versus Estrella. And this is a case that talks about the torture murder statute. And the question is, what is the meaning of course of conduct and relishing the infliction of extreme physical pain in the torture murder statute? And ultimately, the Court of Appeals, when they discuss this, they say the phrase course of conduct in this case, or in all cases, that phrase means it's got to be a series of distinct acts. It cannot be one act. In this case, there was one stabbing motion that killed the victim immediately, and it was charged as course of conduct. And ultimately, they say this is insufficient because it's got to be a series of actions. It's got to be a course of conduct, multiple distinct acts. And they also say that if the fatal blow kills him immediately, then it's not sufficient for a torture murder because it has to have there has to be an infliction of physical pain before the person dies. It requires the defendant to take pleasure not merely in the murder, but in inflicting extreme physical pain before the victim dies. So if the victim dies immediately, it cannot be torture murder. The next case I want to talk about is the case of People versus Fisher. And the issue in this case is whether a sworn juror who believes the defendant followed her home during the trial is grossly unqualified. As we know that a jury that's been sworn, once a juror has been sworn, you can't remove them unless they are grossly unqualified. And the question is, when one juror believes the defendant's following her home and it stresses her out enough that she brings it up during the verdict discussions, is that grossly unqualified? The Court of Appeals here holds that strongly held prejudicial beliefs about the defendant, which are not based on the trial evidence, strikes at the heart of the right to an impartial jury, and therefore render a juror grossly unqualified unless the bias can be cured or set aside. In this particular case, even though there was sort of the juror was rehabilitated to some extent, it was not truly rehabilitation, and the Court of Appeals finds that juror was grossly unqualified and should have been removed, which was not done. Convictions reversed. The next case I want to talk about is the case of People versus Franklin, and the issue in this case is whether the introduction of the Criminal Justice Agency, the CJA report, which is prepared right before arraignment, whether that is a violation of the defendant's confrontation clause. Is that testimonial? That's really the hallmark. That's the question we always ask with respect to a confrontation clause violation. Is the document created with anticipation of being used in a proceeding, in trial? And the answer from the Court of Appeals is no, it is not testimonial. It was not created for use in a trial It was not created as a substitute for trial testimony. It was used for the administrative purpose of facilitating a bail inquiry. And for that reason, it is not testimonial. It's not a violation of the Confrontation Clause. The next case I want to talk about is the case of People versus Green. This is a case in which the defendant testified in the grand jury and allegedly committed perjury multiple times. And the prosecution, charged him with multiple counts of perjury for what he said in the grand jury. The question is that multiplicitous and therefore improper? And the holding from the Court of Appeals is yes. Multiple counts of perjury for one testimony in the grand jury is multiplicitous, and they dismiss one of the convictions for perjury. The next case I want to talk about is the case of People versus Leggett, and it addresses 30/30 adjournment requests and speedy trial time. And the question of when people request an adjournment, but they don't give a reason for why they're requesting that adjournment ever, how much of the time is chargeable to them? The date that they request up to, or the date that the court adjourns the case to? And ultimately, the holding of the Court of Appeals is that the general rule is that when the people request an adjournment to a specific date, the requested time is ordinarily charged to the people, and the time beyond that is presumptively not charged to people because it's not their fault. It's a result of court congestion or some other factor beyond the people's control. But when the people fail to give a reason in the record, when they fail to explain their request for an adjournment, the entire time is charged to the people. The next case I want to talk about is the case of People versus Masano. This is a case that involved police officers pulling a car over and then making observations, and those observations resulted in prosecution for possession of a loaded firearm. The police ultimately engaged in a suppression hearing where it was found they didn't have probable cause to pull the car over, and the judge therefore said that it was not proper the way they pulled it over, but that they were in a proper position to observe, make these observations, and the plain view doctrine allowed them to put into evidence this gun that they reserved and then recovered. That goes to the Court of Appeals, and the issue in this case is whether that's valid or if the unconstitutionality of the stop should result in suppression of the plain view observations. And the Court of Appeals holds, yes, it does result in that. The whole point of plain view is that if the police are in a place that they have a justified, legitimate place to be, and they make observations, those observations are valid. But in this case, where the where the stop itself was bad, they shouldn't have pulled the car over. Those observations are not valid. Those are part of the evidence that get excluded by the exclusionary rule. The next case I want to talk about is the case of People versus Ramirez. And the issue in this case is whether the COVID-19 pandemic policy of having the non-examined jurors wear face masks that protected their face but also blocked some of their expressions, whether that deprived the defendant of the right to be present for jury selection and to pick a jury of his peers. Ultimately, the holding by the Court of Appeals is that it does not. They say that the gravamen of a defendant's right to be present is to hear questions intended to search out prospective bias, hostility, and predisposition, but it does not require that the defendant have simultaneous viewing of all jurors at the same time, all their expressions. And it says the trial court properly balanced the defendant's right to be present during jury selection with the safety of those present in the courtroom and accorded the defendant due process. There's no violation here. Conviction affirmed. The next case I want to talk about is the case of People versus Signius. And the issue in this case is whether the trial court properly allowed a lesser included offense of burglary in the second degree as a lesser included of burglary in the second degree as a sexually motivated offense. The court goes through the analysis and reiterates the rule that if a reasonable view of the evidence can sustain the lesser included, independent from the greater included, from the larger offense, it will be allowed. And they say that in this particular case, the exceptions to that rule, where the people withdraw a charge or they affirmatively abandon the charge, don't apply here. And so the Berg 2 is properly allowed. The judge did the right thing. The conviction is affirmed. The next case I want to talk about is the case of People versus Watts. And the issue in this case is whether a Sex Offender Registration Act risk assessment hearing must be delayed while a sex offender is considered incompetent or lacks capacity to understand what's going on in the proceeding. Or are there sufficient due process protections built into the system that it's okay to conduct a SORA hearing even while a sex offender is incompetent or incapacitated? And the holding from the Court of Appeals is that it is okay. The due process protections are sufficient. They apply the Matthews test, and they find that the weight of authority, they agree with the weight of authority that the state's substantial interest in efficiently assessing the registrant's risk to the community outweighs that of the incompetent registrants to a delay of SORA classification during an indefinite period of disability. And the point here is there's no idea how long a person could be incompetent. It could be years. And do we delay giving someone a risk level for years while we await their competency? And the answer from the Court of Appeals is no, we do not wait. The next case I want to talk about is the case of People versus Weinstein. This is the case about Harvey Weinstein. To me, this is one of the most important cases this year out of the Court of Appeals. The issue in this case was whether the Sandoval and Molyneux applications were properly addressed by the court, and ultimately the court finds that the Court of Appeals finds that the trial judge erred in both its Molyneux and Sandoval rulings by allowing too much in of prior bad acts, both to impeach the defendant, his credibility, and also in the case in chief. Ultimately, this was not harmless error. They find these were abuses of discretion, and they basically, this is a great case to read for all criminal practitioners because it talks about the point of Molyneux and the point of Sandoval, and that they basically say that we've gone too far afield in allowing these prior bad acts to overwhelm the actual crime for which the defendant's being charged. The next case I want to talk about is a case of People versus Williams. This is a case about drug possession following a buy and bust operation. The defendant in this case moved for suppression or a hearing, and the court conducted a suppression hearing about whether or not there was probable cause to arrest the defendant. The court found that the undercover officer who testified was unreliable and said that the testimony seemed to be tailored to meet constitutional muster, so granted suppression on the probable cause issue. The defendant then moved for an independent source hearing, and the judge said, I don't need it. I got all the information I needed from the probable cause hearing. I'm going to deny the application to suppress the independent source, that the undercover officer can testify about the independent source. The issue in this case is whether that was error. Does the judge need to conduct a second independent source hearing, or can they rely upon the testimony at the first probable cause hearing? And the holding from the Court of Appeals here, they don't really address that specifically. They don't say in a broad, bright line rule they must or they shouldn't. They said in this case, the evidence was insufficient at the probable cause hearing to meet the needs of the independent source hearing. It wasn't like there was sufficient testimony elicited that could establish the independent source. And so it's reversed on that ground. The next case I want to talk about is a case of People versus Cord and McDonald. This is a case that talks about the SORA statute, the Sex Offender Registration Act. And under level 1 of SORA, the lowest level, a person must serve be supervised for 20 years from the date of registration. And that's easy if you are registered in New York and you serve 20 years, that's easy to understand. But what if you've served 19 years in Michigan? You were registered in Michigan, or, for example, or Hawaii, and then you move to New York. Do you have to serve another 20 years or just the 1 year? And the Court of Appeals holds in this case that it's 20 years in New York. So it doesn't matter what you've served elsewhere. If you come to New York and you're on the Sex Offender Registration Act, you have to be supervised for 20 years in New York. The next case I want to talk about is the case of People versus Sidbury. This is a case that deals with the psychiatric defense under CPL 250.10. The statute requires that a defendant who wants to interpose a defense of not guilty by reason of mental disease or defect must give that defense theoretically within 30 days of the not guilty plea, like an arraignment on the 30 days of the arraignment, essentially. And in this particular case, the defendant was arraigned, and more than 4,000 days later, for the first time, his counsel, theoretically on the eve of trial, said, I want to interpose a 250.10 defense. And the trial judge, the people opposed it, the trial judge granted an application to not allow the defendant to do this because it was late. And the judge didn't grant late notice to be allowed in this case. And the Court of Appeals had to decide whether that was improper or abuse of discretion. And they find it was abuse of discretion, even though it was 4,000 days late. It's supposed to be done within 30 days. They say that this is depriving the defendant of a right to present a defense, and the sanction of preclusion is not the appropriate sanction when the judge did not properly weigh and assess all the different factors as to why it was so late and why it should be allowed or not. So the trial judge abused his discretion as a matter of law and impinged upon the defendant's right to present a defense and call witnesses when it improperly precluded the psychiatric defense. Instead, the court should have conducted a balancing test, which it didn't do. The next case I want to talk about is the case of People versus Thomas. This is a case in which the defendant allegedly ran a stop sign and the police pulled him over, knew the defendant was a parolee, and after they conducted and completed their stop sign investigation, they held the defendant there until a parole officer arrived, who then conducted a search of the vehicle and found heroin. The question is the heroin subject to suppression because they held the defendant there longer than needed to conduct and complete the stop sign investigation? And the Court of Appeals says it is subject to suppression. They say you're only allowed to hold someone as long as it takes to complete the investigation for which you're pulling them over. Thus, this is the quote, thus an otherwise lawful traffic stop may not be prolonged absent the reasonable suspicion ordinarily demanded to justify detaining the individual. In this particular case, the court applied the wrong standard. They asked for founded suspicion, not reasonable suspicion, and so they remanded it back to court for them to complete it under the right analysis. The next case I want to talk about is a case of People versus Wright. This is a Batson kind of a case, a question about whether the prosecution properly used a peremptory challenge or whether it was utilized in a discriminatory manner. It's an interesting case to read if you have a Batson type of an issue. Ultimately, there's also a question of whether the court said the wrong standard at step one in the three-step process, but the ultimate Court of Appeals finding here was that it did not taint the ultimate decision at step three, and the prosecution did not utilize it for textual reason, and the use of peremptory challenges was upheld. The next case I want to talk about is a case of People versus King, and the issue in this case is whether the new criminal justice reforms that talk about what the people must do, what the prosecution must do before they announce themselves ready for trial, is that retroactively applicable? So this is like a very strange little time frame where in a particular case where the people have announced ready before January 1st of 2020, which was the effective date of the new statute, and then January 1st of 2020 happens, are they all of a sudden unready, or does the readiness that they announced before the effective date carry forward? And the Court of Appeals in that narrow question says it does not render them unready. Before January 1st, 2020, there was no attachment linking discovery obligations to the people's readiness for trial. So when they announced ready before January 1st, they're still ready even after January 1st. The next case I want to talk about is the case of Carlin versus Stanford, in which the issue is whether a parolee's conditions of release, which include not using the internet to access pornography, is that a violation of the defendant's rights, a violation of due process, or is that a fair and reasonable condition of release? And the Court of Appeals in this particular case holds that it is a reasonable imposition. It's a reasonable request to ensure the safety of the public. It's a balancing of the interests, and they say in this case, the defendant is technically still under the supervision of Department of Corrections. This is a relaxation of other conditions they can use where they say you can't use internet at all. So to say you can't use the internet to access pornography is valid and balanced. The next case I want to talk about is the case of People versus McGovern. It's a little complicated. This case, it's a case about consecutive versus concurrent sentencing. The issue in this, the facts in this case allegedly are the defendant allegedly signed a document, forged someone's name, took possession of tires, and loaded on a truck and then drove the tires away. And the defendant was charged with larceny and forgery and was sentenced on both consecutively. And the question was, is that improper, or is that one act, or is it multiple acts? If it's one act, the defendant should be charged concurrently as a matter of law. And if it's not, then the defendant could be charged consecutively. If you have a case like this, you should read this decision. Ultimately, they say that the judge properly allowed this to be consecutive sentences because these are distinct acts. The forgery and the larceny are distinct acts that would allow a judge to sentence a person consecutively. The next case I want to talk about is a case of People versus Shader. This is another SORA kind of case where the issue before the court was whether the judge denied the application to get a downward modification of a SORA level improperly by relying too much on the defendant's previous convictions for violent and nonviolent, sexual and non-sexual offenses. It's one of the factors the judge is allowed to consider according to the statute is the defendant's criminal history. And here there was criminal history, but it was decades old, sometimes multiple decades old. And in relying upon that, the judge denied the application to lower the risk level from a 3 to a 1. The judge did lower it to a 2. And the question was, did the court still apply too much weight to these old convictions in refusing to give it a level 1? And the Court of Appeals says no. There was no abuse of discretion here. The judge was allowed to consider these decades-old convictions in refusing to grant a level 1. The next case I want to talk about is a case of People versus Sharp. In my opinion, this is one of the most important decisions in the criminal context this year. This is the issue in this case is whether a pre-Sandoval conference held in the judge's chambers between defense counsel and the prosecution, where they talk about what the application is going to be, how the prosecution is going to support it, what the defense's position is going to be, and then they go out later in front of the defendant with the defendant present and conduct the actual Sandoval hearing on the record. Is that a violation of the defendant's right to be present for all material stages of the proceeding? It's not ex parte because the defendant had counsel there, but the answer from the Court of Appeals is it is a deprivation. Why? because the defendant has a right to be present for the Sandoval hearing. But a Sandoval hearing is not just what's on the record. They say a Sandoval hearing, the right he has is to be present when the allegations are being made by the prosecution so that the defendant can rebut those allegations. What if the prosecution is wrong? What if the prosecutor has the wrong dates or the wrong facts or the wrong circumstances? That's when the defendant's presence is necessary. So if the conference takes place in chambers, that's where the defendant has a right to be. Essentially, the answer here is that you shouldn't be having these conferences before the actual conference. You shouldn't be having a chambers discussion about Sandoval before it's in front of the defendant in the courtroom. And that's the case of People versus Sharp. The next case I want to talk about is the case of People versus Rufus. And the issue in this case is whether the police are justified in pulling a car over for driving over the fog line, the solid line that separates the rightmost lane of traffic from the shoulder 3 times within 1/10 of a mile. Is that sufficient justification to pull a car over? Is that a violation of the law? And the answer from the Court of Appeals is yes, it is. Pulling 3 times over the fog line within 1/10 of a mile as a matter of law appears to be a violation of VTL 1128A because it fails to drive as nearly as practicable entirely within a single lane. And that's the case of People versus Rufus. The next case I want to talk about is the case of People versus Lawson. This is a suppression kind of a case where essentially there was a suppression hearing as to whether the police should have appropriately pulled a car over. The judge granted suppression, said the police didn't have a right under the theory proposed by the prosecution to pull the car over. The prosecution then offered in a memo later on a new legal theory, a motion to renew and re-argue under a different legal theory using the same testimony that had been given at the original suppression hearing. And the judge reconsidered it under that new theory and reversed himself, said, okay, I'm denying suppression now. The question before the Court of Appeals was, is that proper? Do the people get to have a second bite at the apple and offer a different legal theory for suppression when they fail the first time? And the Court of Appeals says, no, they cannot do that. The people are bound. They have one shot to prove their case in suppression, and they're not allowed to then offer a new set of theories where essentially the defense is not really on notice for that new theory to be able to cross-examine on that new theory at the original hearing. So it was not proper. The suppression decision is reversed. The next case I want to talk about is the case of People versus Castillo. This is a self-defense, what we call a justification kind of a case, where there was it's undisputed here that the victim in this case, the person who was deceased, was the initial aggressor in a fight in a barbershop, and the victim had displayed a knife. The person who was the defendant who was convicted in this case was threatened with that knife, stepped back, perhaps out of the range of the knife, took out a gun and shot the victim, the initial aggressor. And the judge denied the application to present a self-defense charge for justification charge. And the question before the Court of Appeals was that proper? Was the defendant deprived of his right to a defense by failing to give him the justification charge? And the Court of Appeals holds that it was error to not give the justification charge. It's a question for the jury. The question is there a reasonable view of the evidence, viewing the evidence in the light most favorable to the defendant, whether there's a reasonable view of the evidence that the defendant was justified in his actions. And here, it's a jury question, whether the defendant felt or could have felt like he was still exercising self-defense when he pulled a gun out and shot the person who had displayed a knife to him. The next case I want to talk about is the case of Neville versus Toulon, which addresses whether the Sex Offender Monitoring and Treatment Act, which is called SOMTA under Article 10 of the Mental Hygiene Law, constitutionally violates the sex offender's due process rights by failing to provide a prompt ability to oppose claims that they violated release conditions. Basically, the Sex Offender Monitoring Treatment Act has something called SIST, which is the Strict and Intensive Supervision and Treatment statute that says if a person has basically an abnormality, a brain abnormality, essentially, that makes them more dangerous to society, that they are likely to commit another sex offense, an ex parte application can be made, and they have to have an adversarial hearing within 30 days. The question is that too long? Is that 30-day period in the statute, is that unconstitutionally depriving defendants of due process by only giving them an adversarial due process right within 30 days? And the answer from the Court of Appeals is no, it is not. It is not unconstitutional. It's an appropriately balanced, it's legislature appropriately balancing interests of individual and state interests. That's the case of Neville versus Toulon. The next case I want to talk about is the case of People versus Dixon. And as we know, the prosecution can listen to defendants' phone calls while they're incarcerated. There are big signs on the wall that say you're your calls are being recorded and monitored. The question in this case is it okay for the prosecution to listen to a pro se defendant's phone calls while he's in prison as he prepares witnesses that he's going to call at trial, or does that deprive the defendant of his right to present a defense? And the holding from the Court of Appeals is that it does not violate the defendant's right to present a defense. The defendant was out for a large part of this trial, pre-trial, and so he could have prepared his witnesses outside of the jail, or he could have requested that he prepare his witnesses in court outside of the presence of the prosecutor. The defendant's decision to prepare his witnesses on the telephone that says your calls are being recorded and monitored means the defendant was not deprived of his right to present a defense. He just made a call that might not be the right call. The next case I want to talk about is a case of People versus Blue, which addresses the circumstances under which a defendant can proceed pro se to represent themselves at the trial. And obviously, we all know that the court must undertake a searching inquiry to make sure that the defendant's decision to proceed pro se is a knowing, intelligent, and voluntary decision. The issue in this case is whether the judge is not specifically informing the defendant of the maximum number of years, the specific number of years the defendant was facing. Does that render the defendant's decision to proceed pro se null and void? Does that mean he was not knowing, intelligent, and voluntary? Was that not a knowing waiver because he didn't know the exact number of years he was facing? And the holding from the Court of Appeals is that they don't want to do a bright line rule that requires that the specific number of years be given. They say the question is, was there a searching inquiry? There was. Was he adequately warned of the risks of proceeding pro se? He was. They say the numbers, he knew he was facing lengthy prison time, and that was sufficient in this case. The next case I want to talk about is the case of People versus Bakke, and the issue in this case is whether the appellate division, in applying a weight of the evidence analysis of a conviction, do they have to explicitly state that they're charging themselves with the circumstantial evidence charge in a circumstantial evidence case? And the holding from the Court of Appeals is that they don't have to explicitly say they did that, but they do have to apply that charge. So they say the same rules that would apply to the petty jury apply to the appellate division in their weight of the evidence review. They just don't have to explicitly say that they've applied it. We can assume they've applied it in the given case. The next case I want to talk about is the case of People versus Hayward, and the issue in this case is this was a search warrant case where there was a search warrant issued where the police had to knock and announce their presence, and they didn't do so in the execution of the warrant, allegedly. At the trial, the defense counsel failed to request suppression of that of the evidence seized as a result of that warrant. The question is that failure to request suppression on the basis of the police not announcing themselves before executing the warrant, is that egregious enough to warrant reversal of the conviction? And the answer from the Court of Appeals is it is not. There's no federal holding that makes it clear-cut and dispositive such that a reasonable defense counsel must have asserted it. Neither is it clear-cut and dispositive in the New York case law. It's a novel question, and therefore it's not the kind of failure that can warrant reversal in this particular case. The next case I want to talk to you about is the case of People versus Watkins. And the issue in this case is whether the single alleged error on the part of defense counsel is the failure to request a cross-racial identification charge back in 2017 when this trial took place. Subsequently, there was a case called People versus Boone that said that a cross-racial ID charge must be given if requested in an appropriate case, but that happened after this case. So the question is, back in 2017, is this an ineffective assistance of counsel claim that can reverse the conviction? And the holding from the Court of Appeals is that a single error can be the basis for ineffective assistance of counsel, but only when the error is sufficiently egregious and prejudicial as to compromise a defendant's right to a fair trial, and it must be so clear-cut and dispositive that no reasonable defense counsel would have failed to assert it. And in this case, because it was not in 2017 clear-cut and dispositive, it's not egregious enough to warrant ineffective assistance of counsel reversal. The next case I want to talk about is the case of People versus Vaughn, and this case deals with the trial judge's decision as to whether to allow expert testimony concerning factors that affect the reliability of eyewitness testimony. And in this particular case, the application for that kind of testimony was very late in the process. It was even at trial after jury selection had taken place. And the judge denied some of the relief sought, granted some relief, and the defendant moved to say this was depriving him of a fair trial. And the Court of Appeals here says no, it was not abuse of discretion. The judge was allowed to appropriately balance the factors that are in favor of reliability, as well as undue prejudice for delay and all the other factors. And the judge did not, as a matter of law, come up with an unfair abuse of discretion. The next case I want to talk about is the case of People versus Miro. This is a case that presented a couple of different issues. One being the defendant was charged with multiple murders against different victims, different years apart. And the court ultimately found, the lower court found, and the appellate court found that this was not an improper joinder, and it was not abuse of discretion to fail to sever them. And the other question was the trial defense counsel and the ADA had previously had a business relationship where the ADA had written briefs and motions for the trial defense counsel in the past. And is that an unacceptable conflict of interest that voids the conviction? And the Court of Appeals in both those issues says they are not fatal to the conviction. The next case I want to talk about is the case of People versus Robles. This is a case where there were shots fired. The police respond, see the defendant with a gun, say, hey, man, hey, Eddie, man, what's going on? And the defendant makes an incriminating statement about having a gun. Ultimately, the trial judge, the suppression court judge, suppresses that statement. The defendant pleads guilty. The appellate division, in review of that case, says that was the wrong suppression decision. It should have been suppressed, but we're going to keep the conviction because it wouldn't have changed the outcome of the plea. And ultimately, the Court of Appeals here says that was wrong. They reverse that. They say the defendant can have his plea back and keep going because it's not clear that it wouldn't have changed the outcome of the plea. The next case I want to talk about is the case of People versus Lucas. And this is an ineffective assistance of counsel claim. And the question here is it ineffective assistance of counsel as a matter of law if defense counsel did two things: failed to impeach a witness and failed to request a cross-racial identification charge before there was a case called People versus Boone that said it was available for the asking. It was mandatory if requested. And ultimately, the Court of Appeals holds that on this record, the defendant has not established ineffective assistance of counsel or lack of meaningful representation because it's not clear cut that these could have been elected decisions by defense counsel. They could have been strategic. There was no clear cut dispositive reason why they must have done this or else it would have been ineffective. The next case I want to talk about is the case of People versus Brown. And the issue in this case is under what circumstances can the police pull a car over, not for suspected criminal activity, but under their caretaker function. And the Court of Appeals holds that the police may pull a car over out of the flow of traffic, but two elements must be satisfied. First, the officers must point to a specific, objective, and articulable fact that would lead a reasonable officer to conclude that the occupant of the vehicle is in need of assistance. That's one. And two, the police intrusion that then results must be narrowly tailored to address the perceived need for assistance. And once that assistance has been rendered, then further police action must be justified under regular Fourth Amendment and constitutional provisions. And in this case, having the car door open and close was not sufficient to allow them to pull the car over. Suppression granted. The next case I want to talk about is the case of People versus Spirito. The issue in this case is whether parole officers can conduct a warrantless search of a parolee's home on the basis that the parolee's mother sent a picture of the parolee holding a gun. And the Court of Appeals says that is, ultimately the question is the search rationally and reasonably related to the needs of the parole officer's duty? And in this case, seeing the defendant holding a gun received by a picture from the mother is sufficient to allow them to search and then find the gun. The next case I want to talk about is the case of People versus Lively. And the issue in this case is whether parolees have lost their right to privacy such that parole officers can search their home and their pockets and their contents of their home without a search warrant or any reason. And ultimately, the Court of Appeals here holds that while it's true that parolees may have reduced expectation of privacy, they don't lose all their constitutional rights. The question to determine whether parole officers have exceeded their rights here is whether the action is unreasonable and thus protected by constitutional prescription. It turns on whether the conduct of the parole officer is rationally and reasonably related to the performance of the parole officer's duty. And in this particular case, the parole officer went beyond the scope of what was reasonable, and so suppression is granted. The next case I want to talk about is the case of People versus Estwick. This is a jury selection case. It's a Batson challenge case. And the question here is, when the defense has made a prima facie showing of discriminatory use of peremptory challenge, can the judge jump in on the step two of the Batson analysis and give the pretextual reason that the judge thinks the prosecution used the peremptory challenge, and then have it go to step three? And ultimately, the Court of Appeals says, no, that's a gross misunderstanding of Batson. It's the prosecution's burden to establish to give their reasons why they use the peremptory challenge, and the judge then has to determine whether it's a pretextual or non-pretextual reason. The next case I want to talk about is the case of People versus Nektilov. The issue in this case is whether the police are allowed to pull a car over for being excessively tinted. That's all the testimony that came out at the hearing, was that they pulled the car over because it was excessively tinted. They never established that the actual tint was over 70%. Or 70% or more. They didn't talk about a tint meter or any other kind of objective devices they used to determine the level of tint. And ultimately, the Court of Appeals reversed the suppression decision, said this should have been suppressed because, as a matter of law, the people failed to establish in a suppression hearing that there was a basis for the stop. Rather than say it's excessively tinted, which is a conclusion, they have to give the basis for that belief. Next, we're going to talk about the contracts cases. The next case I want to talk about is the case of Petróleos de Venezuela versus MUFG Bank. And the issue in this case is in a contract involving securities where the choice of law provision exists that selects New York law, which law controls over the validity of the security itself, New York law or the law of the origin of the security, which is Venezuela. And the holding from the Court of Appeals here is that because of Uniform Commercial Code 8-110A1, even if there's a choice of law of New York, the validity of the origin country, of the origin jurisdiction, controls as to the jurisdiction, as to the validity itself of the security. So in this case, it's Venezuela. Their law controls about whether the security is valid. Everything else can be controlled by New York. The next case I want to talk about is the case of Audthan versus Nick and Duke. This is a case where the issue is whether an anticipatory repudiation and a breach of contract are both sufficiently alleged in the complaint. If you have a case involving those, this is a good case to read. They talk about those in depth. But in this case, they find that they both are sufficiently pled and can move forward. The next case I want to talk about is the case of Mulechek versus ExxonMobil Corp. This is a case where the issue is when the contract unambiguously prevents certain shareholders from filing a lawsuit, but other parts of it ambiguously would allow it. Are they allowed to file that lawsuit? And ultimately, the Court of Appeals says we have to follow contracts to the extent we can, as long as they're not against public policy. And in this case, because it unambiguously prevents the plaintiffs from filing this lawsuit, they're not allowed. The case is dismissed, even though other parts of the contract are somewhat more ambiguous. The next case I want to talk about is the case of Wu versus Uber. This is a case where the issue is whether a click wrap agreement, like a smartphone agreement, when you try to use an app and it says, you have to agree to all these terms of service to continue using the app. Is that click wrap agreement valid, enforceable, and will it even remove, if it has a mandatory arbitration provision, will it even remove a case that's currently pending from a trial calendar and put it in arbitration? And the answer from the Court of Appeals is we are bound by the agreements we sign, even if we don't read them. And in this particular case, the plaintiff here was bound by the agreement in the click wrap. In the agreement on her smartphone, and therefore her pending case was being removed to arbitration on that basis. The next case I want to talk about is the case of Farage versus Associated Insurance Management. And the issue in this case is who has the burden to prove on a motion to dismiss that a suit limitation clause in a contract is unreasonable, impossible, or unfair. And in this particular case, it's an insurance agreement where there's a requirement that you file a lawsuit within 2 years, but you have to complete the project within 2 years. So if there's a building that's completely broken, a big building that can't be reconstructed within 2 years, and it takes longer than 2 years to rebuild it, and a lawsuit is filed after that 2 year period, and there's a motion to dismiss, who has the burden to establish that it's impossible to rebuild a building within 2 years? Is it the plaintiff or the defense to undermine? And ultimately, the Court of Appeals says it's the plaintiff's burden to establish that it was impossible to comply with that suit limitation clause. And in this particular case, they failed to sufficiently allege facts in support of that, and they lose. And those are the cases from 2024. Now I'm happy to answer any questions.